Well, good morning, everyone. And to our guest here today, welcome to the Department of Justice. Lisa, thank you for your incredibly kind introduction, but more importantly, thank you for your fantastic leadership of the Office of Access to Justice. I also want to recognize everybody who is here today from ATJ for your absolutely tireless efforts here. Now, as I would expect just about everybody here knows, this office was created by then Attorney General Holder back in 2010 to ensure that we were doing everything we could here at the Department of Justice to increase access to justice in both the civil and criminal arenas, regardless of race or wealth or status. And the work that this office does is truly inspiring and is really central to the mission of the Department of Justice. Now, we've got a diverse crowd here today, made up of prosecutors and public defenders, law enforcement officers and community stakeholders, legal advocates and community activists. And this diversity is really a reflection of the fact that we all have a role to play in improving our system of justice and in ensuring that it lives up to our founding ideals. That's especially true for public defenders. As Lisa mentioned, as a federal prosecutor in Atlanta for over 20 years, I've had a lot of experience with public defenders. I have seen firsthand the relentless dedication to the cause of justice that public defenders exhibit each and every day, oftentimes in the face of difficult, if not impossible, circumstances. Public defenders are often understaffed and under-resourced, and that's not how our system is supposed to work. And I so admire what all of you who are public defenders here do every day to ensure that an individual's access to justice is not determined by how much money he or she has. Now, as Lisa mentioned, as you all know, we are at a crucial moment right now in our history where there's a significant consensus that has been built around the need to reform aspects of our criminal justice system. For the first time in a very long time, we have folks from both political parties on both ends of the spectrum who are finding common ground. In the last couple of years, I have spent time with people from all backgrounds, with correctional officers and inmates, with law enforcement officers and public defense advocates, from community leaders and community activists. And despite the differing roles that each of them has, and sometimes the differing perspectives that they have, the common theme has been clear from this, and that is that the status quo needs to change. Now, we're trying to do our part at the Justice Department. We have directed our prosecutors to stop charging mandatory minimums for certain low-level, nonviolent drug offenders. As Lisa mentioned, we have embarked on an historic clemency initiative, allowing the president to commute the sentences of more individuals than the last 11 presidents combined. And I'm sorry, Lisa, but I have to correct you on one thing. It's actually 744 individuals right now, but who's counting? With many more to come. And we have significantly bolstered our reentry efforts here, trying to ensure that once individuals have paid their debt to society, that they have the tools that they need to be able to be successful when they reenter their communities. Now, all of this stuff is really important, but as we are strengthening our criminal justice system, I think we also have to remember that a core component of our system is that everyone, regardless of race or class or status, has access to competent counsel. Now, more than half a century ago, the Supreme Court affirmed what they called the obvious truth that every defendant charged with a serious crime has a right to an attorney, even if he or she cannot afford one. In Gideon, the court recognized that adequate legal representation for the most vulnerable among us is really the bedrock of our entire criminal justice system. And while our nation has made progress in removing barriers to quality representation, the unfortunate reality is that 5 decades later, the promise of Gideon remains unfulfilled for far too many individuals in our nation. In every corner of our country, there are public defender systems painfully understaffed and under-resourced. Some offices have had to close their doors to new clients, and others are forced to represent a seemingly never-ending line of clients without the attorneys that they need to be able to provide adequate representation. The Bureau of Justice Statistics found that between 1999 and 2007, the number of public defenders increased by only 4%, but yet the caseload increased by over 20%. Now, when managing such huge caseloads, it can be difficult, if not impossible, for counsel to carry out their legal and ethical duties to their clients. At the department, we are embracing our responsibility to ensure that our country lives up to the promise of equal justice under the law. For example, in 2012, ATJ, under Lisa's leadership, launched the Legal Aid Interagency Roundtable, which brings together 22 different agencies from across the entire government to work to integrate civil legal aid into a wide array of federal programs. Now, what this means is that this roundtable has unlocked millions of dollars in assistance that can be used to connect Americans and legal aid providers to really vital services that are necessary, vital services in the area of health care and housing, education and employment, and other core needs for every American. In 2015, ATJ supported efforts to prevent the criminalization of homelessness. And earlier this year, the department issued guidance to state and local courts regarding their legal obligations with respect to the assessment and enforcement of court fines and fees, doing this to ensure that individuals are not jailed for being poor. The department has also filed 4 statements of interest or amicus briefs in courts throughout the country, arguing a constructive denial of the right to counsel in jurisdictions where public defender services were so under-resourced and understaffed that they essentially resulted in indigent defendants having counsel in name only. At the same time, earlier this year, we announced that the department was awarding $3.3 million to cities and states and defense advocacy organizations to support their indigent defense work. These awards will expand the number of cities who have an opportunity to participate in BJA's Smart Defense programs. These are programs where cities can use research and data to be able to ensure that their criminal justice programs are as effective as possible. And it also provides investment and risk assessment tools to be used in the pretrial release decision-making process and in reentry planning. Now, while all of these steps are important, and we hope that they're meaningful, our work is far from finished. And one area I'd like to talk a little bit about today is access to counsel at bail hearings. While Gideon and subsequent cases make clear that the Sixth Amendment guarantees court-appointed counsel to every indigent defendant who faces incarceration, there's still a question of when, precisely how early in the criminal proceedings, the Constitution requires that counsel be appointed. This is especially important when we're talking about a defendant's initial appearance. An initial appearance where a judge is likely to decide whether to detain the defendant or to release him on bail. Now, in the federal system, the rule on bail hearings is clear. Under the Bail Reform Act, defendants have a right to an attorney, and if they can't afford one, they have a right to have an attorney appointed for them. And that makes sense. The Constitution not only entitles defendants to a presumption of innocence, but also protects them from excessive bail. Yet many indigent and low-income defendants are unfamiliar with the full extent of those constitutional guarantees. Now, without a doubt, there are some defendants who are either likely to flee or who are so dangerous that they should be detained. But others should not. And given the serious consequences that can flow from a pretrial detention decision, from losing a job and housing, to missing school and defaulting on debts, it's crucial that defendants have counsel advocating for their rights. 8 years ago in Montgomery versus Gillespie County, the Supreme Court held that the Sixth Amendment right to counsel attaches at a defendant's initial appearance. An initial appearance before a magistrate judge that is an important moment when the defendant learns about the charges against him and his liberty is subject to restriction. But the court has not gone the extra step and stated that a magistrate must appoint counsel for an indigent defendant at that point in criminal proceedings. A number of states, nonetheless, have taken that step and now ensure the availability of court-appointed counsel when a judge is setting bail. Other states, though, have not. And it's not uncommon for indigent defendants in some jurisdictions to be held in jail for weeks or even months before they're assigned an attorney who can advocate on their behalf. That's wrong, and that is inconsistent with our basic notions of fairness. In 1964, Attorney General Bobby Kennedy testified before Congress on legislation to overhaul the Federal Bail Reform Act, and he expressed his concern that bail had, in his words, become a vehicle for systemic injustice. And he diagnosed the problem pretty bluntly, stating that far too many men and women remained in jail simply because they cannot afford to pay for their freedom. Now, certainly much has changed since then, both at the federal level and across the states. But our Constitution prizes the right to counsel in criminal proceedings. And regardless of whether the Supreme Court determines that the Sixth Amendment requires it, it is clear to me that our nation's core values demand that all jurisdictions recognize the need for court-appointed counsel at a bail hearing. Not only is the defendant's liberty at stake, but so too is the fairness of our criminal justice system. Now, we may be in the closing days of this administration, but the fight for fairness will continue well into the future. We hope that others will continue the effort to secure access to counsel, including at bail hearings. And moving forward, we're going to keep voicing our ongoing support both for federal and state defender programs, including appropriate funding and resources. In Justice Black's historic Gideon opinion, he observed that the right of one charged with a crime to counsel may not be deemed fundamental and essential in some countries, but it is in ours. Thank you for what you all do every day to make our shared obligation to fulfill that promise a reality. Thank you.